One of the most important strategic decisions in immigration law is choosing the correct process for a person's situation. Many people compare options by asking which one is easier, which one is faster, but that approach can lead to serious consequences. Refugee claims and humanitarian and compassionate applications, often called HNC applications, they serve different purposes and require different kinds of evidence. So in this video, the difference is broken down in plain language so the right process can be chosen based on the legal test, not online assumptions. This is Nora Eze with Nora Law Professional Corporation in London, Ontario, Canada. This video provides legal information and general education. It is not legal advice. Today we're discussing refugee claim versus HNC applications, how to choose the right path and avoid costly missteps. The first step usually is to ask the right questions. Are you seeking protection from danger, which is refugee claim? In order to do that, let's define what a refugee claim is. A refugee claim is a protection process. The legal focus is whether the claimant faces serious risk if returned to their country, such as persecution or other serious harm recognized under Canada's refugee protection system. Refugee claims are usually determined by the IRB. Credibility and objective evidence central. That means that the decision maker will look closely at whether the story is consistent, whether the facts are supported, and whether country condition evidence aligns with the person's situation. So essentially, a refugee claim is not designed to fix a long-term status problem simply because a person has lived in Canada for a long time. Refugee is not for you. It is designed for protection. When a refugee claim is filed without a genuine risk basis, it can create credibility issues and future immigration problems. Now, if the core issue is not risk, if it is about establishment in Canada and the hardship of living, the analysis shifts. That brings the discussion to HNC applications. This application is quite different. It is usually decided by the IRCC and focuses on humanitarian factors. Common factors could include establishment in Canada, hardship on return to the country of origin, the best interests of the children directly affected by a decision to remove. The HNC process is generally document-based. The case is built through evidence and written submissions, not primarily through a tribunal hearing. HNC is not a substitute for refugee claim either. It is a discretionary pathway, and outcomes often depend on evidence quality, organization, and persuasive presentation. Next, we're going to explain why people often end up in the wrong process, because that is where avoidable mistakes tend to happen. People usually fall into the trap of, oh, why am I in the wrong process? Most people receive informal advice that oversimplifies their options. They may be told, oh, refugee claims are faster or that HNC is safer. Those statements are incomplete because strategy depends on facts, timelines, and legal risk exposure. A person's immigration history can also affect what options are available and how risky a particular path may be. For example, a person facing enforcement has different urgency than someone with stable temporary status. A person with children in Canada may have a stronger HNC profile because best interest evidence becomes central. Another example is a person who has direct personal targeting and may have a stronger protection profile suitable for refugee proceedings. So after deciding which legal test actually fits the person's situation, the next question becomes, what evidence is needed? So what do you have to prove? What evidence do you need in order to succeed in a refugee or a HNC application. In a refugee claim, evidence is primarily about risk and credibility. And this can include personal narrative evidence that is consistent and detailed, objective country condition evidence, documents supporting your identity, incidents, and threats, and any evidence that corroborates personal targeting. However, in an HNC application, evidence is primarily about humanitarian factors. This can include proof of establishment in Canada. That would include your work history, your school, community involvement. Then there is the hardship evidence. This could be medical grounds, economic, safety, stigma, discrimination, evidence about family impact, and there is also evidence addressing the best interest of any child or children affected. So in both processes, organization matters. Decision makers respond better to clear, structured records than to unorganized document bundles. A well-prepared record makes it easier for the decision maker to understand the legal theory and the supporting facts. Next is a brief wrap-up that provides a simple decision framework. If deciding between a refugee claim and an HNC application, strategy should be based on the legal text and the evidence, not assumptions about speed or convenience. If the core issue is protection from serious risk or return, the analysis usually starts with refugee protection framework. However, if the core issue is hardship, establishment, and humanitarian circumstances, the analysis usually starts with HNC factors and discretionary considerations. Nora Law Professional Corporation can review the facts, identify the legally appropriate pathway, and provide a clear plan. To request an appointment, please visit noralaw.ca and do well to subscribe to our video for more legal insights.